on YouTube now. Okay, so let's, hi Kasia, we can now begin. All yours, you have the rights to, the floor is yours. Please take it as you would like.
Thank you very much. So I'm going to start sharing the screen so you can start looking at the presentation. Everyone can you see the screen? Just let me know that it's okay. So what you should be seeing is the negotiating, the topic basically of our webinar today. Negotiating multi-party conflicts of interest at the United Nations level. It's my pleasure to be the speaker in this webinar. My name is Professor Kasia Jagodzinska. I'm a professor specializing in negotiations at Webster University and at the University of Neuchâtel in Switzerland. I'm also a consultant for the United Nations in Geneva in Switzerland, and also an international trainer for the Schroeder Negotiation Institute and founder of Negotiation Booster. All of these occupations are centered around negotiations and conflict management in intercultural settings, in multi-party settings. So this is what I'm going to be talking about today in this webinar. What I've presented is specifically a focus on what are the challenges and what are the opportunities of negotiating multi-party, multi-stakeholder deals, or negotiating the resolution of conflicts of interests between the multi-parties that are involved at the United Nations level. So before we proceed with the core of the discussion today, one needs to understand what is a conflict of interest. So we talk about at the United Nations level, I work with the SUN Secretariat. What we understand as a conflict of interest, or the prevention, or as we call it, the management of conflict of interest, is to make sure that secondary private interests do not supersede the primary purpose of establishing synergy between the multi-stakeholders. So the role of myself as a consultant for the SUN Secretariat is to ensure that all the stakeholders' interests are aligned in a mutual effort to maximize the benefits of cooperating together. Now, what I mean by multi-party, multi-stakeholder interests is what you can see in this second slide here. This is the platform of the stakeholders that we are dealing with. So you have the international secretariats, you have the national private sector, you have national NGOs, ministries, UN agencies, national focal points, the donors networks, civil society networks, and business networks, and of course, also the consultants, the senior advisors to the United Nations with whom we interact here locally. So you can see, looking at this slide, that the name itself already justifies that it's multi-stakeholder. There's a lot of interests. Now, in negotiations, it's difficult enough when there are two parties and we say that the driver of a negotiation are variety of interests. It's difficult enough when we only have the standard one-to-one negotiation, but imagine how elevated the level of complexity can get when we have more parties involved. By more parties involved, if you look at this slide again here, you'll see that there are different understandings, different interests also related to the character itself of these parties. And of course, add to that the additional layer of intercultural differences, which obviously will also affect the negotiation process. And this is what I would like to briefly talk to you about today, so that you understand what are some of those aspects that are very fascinating. It's very fascinating to bring these all these parties together at the negotiation table. Primarily, the fascinating element is obviously the human element and how these interactions will affect the cooperation, the business conduct, and so on, for a higher good. This, for example, what we're doing at the SUN Secretariat is we're dealing with, its SUN stands for scaling up nutrition. What we're dealing is we're trying to stop malnutrition in underdeveloped countries. So this level of complexity has a very rewarding side, in the sense that you have the possibility of helping people that are less fortunate. So now let's start, let's emerge more into the topic, into this complexity that I've mentioned several times already. So let's uncover the cards, what that complexity actually means. So here, and this is, you'll see, this is a definition, a visualization, not a definition as yet, a visualization of a negotiation. And you'll see, typically in business operations, you'll have, like I mentioned already, one-on-one. At the UN level, you'll have multi-party. Doesn't matter, the definition is the same. It's an interaction between, at the United Nations level, at least two parties. We just saw the variety of parties that are engaged in this dynamic, who have common, different, and conflicting interests, aimed at reaching a mutually acceptable agreement with each other. Now, two things are interesting in this definition. Mutually acceptable agreement is one of the fundamental, the key word here is mutually acceptable. The key words actually are mutually acceptable agreement. Obviously, in agreements or deals can be imposed, but that doesn't matter that they will be actually executed. And a successful negotiation, a successful cooperation, a successful relationship ends not with signing a contract, not with signing a document, but actually with implementing the terms that were negotiated, that were discussed and agreed on between the parties. So this is very important. Our role as seniors advisor, my role as senior advisor at the United Nations level, is linked to trying to bridge together the interests, and I will pass on to describing and defining the interests. My role is to bridge these interests so that all these stakeholders that you just saw on the previous slide, that they can actually accept this agreement. As you can anticipate, this is where the level of complexity highly rises, to how to actually get these people to cooperate and so on. And I will talk about that, what are some of the conditions that need to happen for mutually acceptable agreements. Moving on to the second element that I said is quite, that I drew your attention to, that is quite interesting in this discussion definition, is that there are three types of interests. There are common, different, and conflicting, as you can see in the definition. The common ones are the ones that bring the parties together. The common ones are those interests that basically allow the parties to meet at the negotiation table or meet virtually in e-negotiations. Those are the ones that drive the dynamic between the parties. As long as there is dialogue, as long as there is discussion, as long as there is the will to cooperate, that means that there is a common interest in the cooperation going forward. The role of the negotiator will be to identify what that common interest is and to build on that interest. Then we'll have different interests. The different interests are, I would say, the least dangerous ones in a negotiation. Simply, difference is simply a result of divergence. Different interests are not conflicting interests. Conflicting interests, by contrast to different, are those that the satisfaction of an interest of one party will be to the disadvantage of the satisfaction of the interests of another party. So this is where the level of complexity is a little bit higher. Now, there are two schools, two approaches to negotiation. There is the famous principled approach to negotiation, which was developed in the 1980s at Harvard by two professors, Fisher and Urey. This is the famous win-win approach, and the principled approach to negotiation, which assumes that it's always possible to maximize the benefits of limited resources or the benefits flowing from an interaction. It's always possible to maximize for both parties. And here, the principled approach to negotiation says, start any interaction with common interests. build on those common interests, spend time, spend energy, spend effort on them, because it's going to be less likely that once this effort and energy and time have been invested, then it's less likely that the parties will break the negotiations. Then there's the second approach, a different approach following the FBI model. For example, the Schreiner Negotiation Institute, we train executives according to that model. Says no, start with the conflicting interests first to clear the air, and then move on to the common and the different interests. Here at the United Nations level, we tend to try to bridge the common interests first. We try to build the grounds of engagement, and then pass on to the different and conflicting interests. But again, there's no recipe that says this is the recommended approach for every situation. In some situations, we start with the conflicts first, especially at the United Nations level, if there is an evident conflict of interest. By evident, I mean, I defined it earlier, but sometimes it's borderline either a conflict or a conflict of interest, and the parties themselves are not convinced or are not sure what type of conflict they're dealing with. When it's clear, then we start with the conflicting. Very often we tackle the biggest problem first. So those are the two possibilities that a negotiator has, and also the advantages and the disadvantages of each. Now, I would like to present to you some of the principles of multi-party engagement, and these are the SUN principles. You'll find them on the SUN website, the Scaling Up Nutrition website that I mentioned to you. They're similar for different departments and different secretariats at the United Nations level. You'll see that there is a common thread or a common link. I chose to present to you the ones that we follow at our secretariat. So because basically these principles flavor the way we proceed and the way we cooperate with these multi-party stakeholders, so that you can get an understanding. First of all, be transparent about intentions. Transparency in communication. So very often the majority of our training, the majority of our consulting services and engagement at the SUN secretariat level is on building trust among the multi-party stakeholders, building trust, building inclusive dialogue, engaging the parties in this effort of finding mutually acceptable ways of going forward together. So transparency is quite an important item here. Then be inclusive, which means engaging all to the extent that it's possible, engaging those multi-stakeholders in the process. Now, this is very interesting if we look at it from the perspective of negotiation theory and negotiation practice. Inclusion means including the other person in the process, means empowering them in the process. Some negotiators may cringe and may think, okay, is that not contrary actually to the objective of a negotiation, that is to maximize my interests and reach a mutually acceptable agreement, but nonetheless also get my interests met in the negotiation? I would say that in empowering the other person is what increases the likelihood of the agreement being accepted. Imposing seldom brings long-term sustainable agreements between people. There's even a saying that I've often repeat, which goes, "He who complies against his will is of his opinion still." So obviously what the saying means is that sure, you can impose short term, but the question is this going to be a long-lasting agreement? Practice shows that not necessarily. Principle number three, be rights-based. So basically be embedded in certain ethical standards, also certain customary ways of doing things, obviously be in accordance with existing laws and regulations and so on, and human rights as well, which is a big a big topic at the United Nations level. 4, be willing to negotiate. And here, this is a concept that you'll see in any theory. I mentioned the principled approach to negotiations. I mentioned the Schroeder approach, which follows the FBI concept. You'll see that the willingness to negotiate is actually one of the indicators for the negotiator to step in. So this openness to negotiation leads to opening the window of opportunity, as we call it in negotiations. Principle number 5, be predictable, mutually accountable. So we're not talking about only mutually acceptable agreements, but in order for agreements to be mutually acceptable, parties have to be mutually accountable also, which means that they have to be accountable and responsible for the decisions and the results of those decisions that those decisions may actually lead to. 6, be cost effective. Obviously, since we have so many, since the role of the Sun Secretariat, for example, is to remedy the situation of countries and nations and situations that are more difficult than we're facing here in Geneva, then our role is basically to be cost effective so that those resources can go to helping others. 7, be continuously communicative. I mentioned that already. Communication, trust, open dialogue are one of the fundamentals basically of our interactions. Act with integrity in an ethical manner. I mentioned already the appreciation and the respect of ethical standards, human rights, integrity in behavior, and so on. Be mutually respectful and do no harm by behavior. So I find this framework, it resonates very well with my system of values and what I believe in. And that's why, and it also sheds light on the way that the characteristics, the spirit, the dynamic of what we're doing. And I find that it fits very well with the negotiation principles as well that work in practice. So now you have an understanding of that as well. One of the elements of complexity is cultural differences, the impact of cultural differences on conflicts of interests. In negotiations, we have the saying, Lane Thompson actually mentioned this as in her book as one of the truths, 43 truths on negotiations, knowing why the fish swim. Very often in psychological tests, you show people, the respondents, you show them images of, let's say this image was shown to a group of representatives from collectivistic and individualistic cultures, and they were asked, what do you see in the picture? Collectivist cultures, representatives of collectivist cultures told stories of collective effort, swimming towards a common goal, directing the energy and the time towards the achievement together. Individualistic cultures saw the situation differently, saw it as an individual competitive effort with an alpha male who excels in this process. So the stories vary depending on our culture, depending on our paradigm, depending, of course, also on our system of pertinence of an individual. So the way in which we perceive and respond to reality. Therefore, in negotiations, it's recommended to know in which direction and why do the fish swim. Here, I've identified based on my practice at the UN level, based on my practice training executives internationally, based on my academic practice and my experiences at universities with students, I've identified the elements which may cause difficulty in negotiations. So I'll go over each of these elements one by one so we can better understand their impact on negotiations and conflicts of interest resolution at the United Nations level. Definition of negotiation, it will vary depending on the culture. For example, if you look at French literature, very often you will notice that that negotiation is defined as the last instance. So there is a conflict, then there are usually nationwide strikes, and there's a disruption in the functioning of businesses and society, and then to resolve the situation, there's a negotiation. If you look at American literature, like I said, the foundation of which is the principled approach to negotiation, you'll see that negotiation is an effort of mutually investigating what are some of the possibilities of maximizing the benefits of the parties involved. If you look at, for example, Polish literature, you'll see that negotiation is defined as an effort of gathering information, each party on their own, and then using that information to maximize the interest of one party or both parties involved. But it's not an effort where you come together and explore together certain opportunities. So the definition we need to understand. So when we look at this platform at the United Nations level, as senior advisors, we need to understand how do these different parties define negotiation to make sure that we're operating on the same dictionary page, which may have serious implications for the process going forward. Second, selection of negotiators itself will vary. Obviously, the first connotation, mental connotation that we have when we think about selection of negotiators is gender. So are women seen as valid, as legitimate negotiators, or are they not perceived as such? Is age a condition, seniority, age, experience or not? And here again, it will differ depending on the types of culture. I remember when years ago, I used to conduct negotiations in the Middle East very often. Back then, I had to have also male negotiators who would sometimes play the front role. I would be backstage sometimes because that was culturally driven as well. In certain cultures, such as the French culture, for example, the hierarchy is very top down. Seniority is an important element. In some cultures, age is not as important as fresh new ideas, experience, and so on. Some say experience comes with age, but you can also get quite a lot of experience at a young age when you set up your own companies and so on. For example, the US culture sees things that way and so on. So we need to also understand who is seen as a legitimate negotiator at the negotiation table, not only for procedural reasons, but more importantly also to understand what is your role, strategically, what is your role, so that strategic perspective will not impact your personal outlook on the situation. In other words, what I'm trying to say is that if you do not understand that in certain cultures, you are not seen, let's say, as a young female negotiator, as a legitimate speaker at the legitimate voice at the negotiation table, then this may impact ultimately your negotiation power, impacted obviously adversely. So you need to understand the rules of the game that you are playing. 3, protocol or degree of formality. Here it differs again depending on cultures. So our agreements, does everything have to be written down? How detailed are agreements? So how detailed is the deal-making process? Do we put all the details in writing? Do we anticipate all the things that can go wrong with a negotiation and so on? Or is it more our gentleman's agreements acceptable as well, and so on. Then communication itself. Today I've chosen to speak to you to show you examples. We could have a day-long session on the impact of communication, intercultural differences and so on. Today I will just speak to you about low and high context cultures. I will not speak about other dimensions such as Hofstede and other theories, face, dignity, and honor cultures and so on, because as I said, this lies outside the scope of today's topic. Nonetheless, we have to mention communication differences and how they impact the negotiation process. So whether, and I will explain this later on the next slides, whether information is explicitly transferred, implicit, and so on, what is the attention paid to body language, nonverbal communication, verbal, and so on. Then time sensitivity. Here, in terms of time sensitivity, what we mean is approach to time, monochronic versus polychronic cultures. For example, what happens when a representative from a monochronic culture tries to do business or negotiate with a representative from a polychronic culture? Usually it's a disaster, because one party who is very agenda driven strictly adheres to deadlines, milestones, starting and ending meetings on time within the indicated business hours, has to do business or has to negotiate or resolve a conflict with a party who is multitasking, for which time flies in a more fluent manner. Deadlines are just indicators of what can be overpassed, and so on and so on. So you need to also understand, again, just as in that point on selection of negotiators, you need to understand time sensitivity, because time pressure or pushing deadlines is also a negotiation tactic. So you need to understand and differentiate whether time is being used as a tactic against you, or whether time is driven by cultural differences in order not to allow this to affect your negotiation power. A very important element, if we were looking at Hofstede's dimensions, cultural dimensions, you'd see that there is one dimension that is called uncertainty avoidance, UA, the UN dimension. It's reflecting the attitude towards risk. We need to understand which representatives, which cultures, and so on, which multi-stakeholders are more prone to taking risks, and which will be more risk averse in their operations as well. We could have a discussion. Of course, this will vary depending on the stress level of the individual. This will vary depending on gender differences. This will vary depending on economic, political patterns. This will vary depending on the nature of the business transaction itself, and so on. Nonetheless, it's one of the elements that we need to be aware of. Then what I mentioned earlier when I told you this story about the psychological tests, this reference, it was not a story, a reference to the psychological tests, were groups versus individuals, so collectivist versus individualistic cultures. This is also something that a negotiator at the UN level needs to be aware of, simply because the collectivist cultures tend to attend the negotiation in large numbers. Very often unskilled negotiators, or those who are not yet interculturally sensitive, will ask the question, well, since there are 10 people at the negotiation table, should we bring 20 people? My answer is, you need to understand the context. Is it a collectivist or individualist culture? Is it a tactic used against you? And third and most important, the less people you have at the negotiation table, the better. The more you have, the more likelihood of divergences in opinions, beliefs, interpretations, values, and so on, that may itself create conflict at the internal level of the team. Nature of agreements as the next element. Again, this is related to the degree of formality. So what is the nature of agreements? Where are agreements concluded? Is the focus more on the task side, or is the focus more on the relationship side? And last element, emotionalism. How acceptable socially is it to display emotions, or whether the scale tips towards less display of emotions, more poker face in the interactions, and so on. So these are the elements that may impact and do impact the resolution of conflicts at the United Nations level and beyond in international business as well. I've mentioned communication. What I want to present to you very briefly is the low versus high context cultures, just so that you get an understanding of one of the elements, fascinating elements that have an impact on the conduct and on the dynamic between the parties. High context cultures and low context cultures relate to the way that people communicate with each other. So here in high context, a lot of information is implicitly transferred during the communication process. There's a larger importance on long-term relationships, and loyalty, and there are fewer rules and structures that are implemented. To compare that to low context cultures, Switzerland, for example, is a low context culture. Explicit exchange of information. So we say it as we see it, basically. Rarely, seldom is anything hidden below the waterline. Implicit means, I forgot to mention that, for example, in Asian cultures, implicit means that you have to have the ability to read between the lines, or how they call it in Asia, read the air. So be able to understand the unspoken. Here, explicit, low context, it's a little bit easier in that sense, that it's explicit at least. However, you're also going to have a higher degree of formality, so more rules, more standards, more task orientation, and relationships tend to be short term. This is another very interesting element of our discussions of the topic of today's discussion. I wanted to present to you the integrative approach to negotiations at the UN level that we use in order to maximize the chances of reaching mutually acceptable agreements. This model that I'm going to present to you resembles the principled approach to negotiations. It has been adopted to our practice at the United Nations level. So first of all, what we have is the common objective that has to be identified, and consequently engaging both parties in the quest for finding a mutually acceptable agreement. Second element is identifying what are the interests of the multi-parties that we have present in the negotiation dynamic. So not only we differentiate in negotiations between positions. Position is the expression of what I want. So if we talk about a simple example, a salary negotiation, the position would be the number that you're asking for. The interest is what is below the waterline, what is driving that position, basically. And a skilled negotiator or an advisor to the United Nations has to identify what are the interests of all these stakeholders that we've seen before. Then, in order to avoid a battle of arguments, we have to find objective criteria to base our logic on. So objective criteria are those that are independent of the will of other part of basically subjective, not subjective, but objective, not subject to your own interpretation and so on. Objective criteria are, for example, ethical standards, common laws, common regulations in international business practice, custom, usage, and so on are perceived as objective criteria. So in other words, anything that is independent of the will of other parties. Then, zone of possible agreement. This is a concept of financial terms, which means the overlap between the maximum that one party is willing to give and the minimum that the other party is willing to accept. This may be in financial terms. However, what happens if there is no overlap in financial terms? If we still want to conclude the agreement, we will refer to what is called options, creative options, introducing options to bridge the lack of overlap between the financial constraints that we're facing. Communication, as I mentioned before, explicit versus implicit. The importance that one places on reading body language, reading paraverbal communication, which is the third type of communication, which refers to the way that things are said, understanding that, and understanding what is the context and what may be some of the consequences of what is said and unsaid, especially when we have cultural differences and so on. Creating standards and rules of communication and procedures, implementing the rules and techniques of nonviolent communication as well in the face of conflict, since we're dealing with conflicts. Therefore, we have to communicate with each other. Conflict management is an art and a science of resolving differences, conflicts, by use of non-violent means. So this has to be also, how do people communicate? Primarily, they communicate by speaking with each other and so on. So this obviously has to be mirrored in the language and in the communication process between the parties. Then the relationship. There are always two constituents to a negotiation: the task that we have to achieve, so let's say the conflict of interest that we have to achieve at the resolve at the United Nations level, but also the second delicate task is not to detriment or not to ruin the relationship between the parties. In some cultures, we build the relationship first, then we can pass on to the task. In other cultures, task first, then the relationship. And last element is the BATNA, so your alternative, your plan B, which is outside of the negotiation, your fallback position in case this negotiation does not bring the desired results, versus options that I mentioned before that are inside the negotiation themselves. So BATNA outside, your plan B, your alternative that increases your bargaining power simply because you convince yourself and you craft an alternative in case a given situation cannot be resolved, versus options in case there is no zone of possible agreement in financial terms, but we nonetheless want to reach an agreement. Last thing that I wanted to mention to you, so that we have 5-10 minutes before we close the session for me to address any questions that there may be. Last thing, if we're looking at the level of complexity, undeniably its existence, are there any UN universal principles that we can adopt in our endeavors? Here I follow the theory of negotiation linked to behavioral finance, linked to psychology studies, and so on. 3 fundamental principles that we recommend is the reciprocity principle, reinforcement, and similarity principle. Reciprocity principle is basically the tendency, the universal tendency for people to treat others the way they are treated. Fundamental, universal, across cultures, doesn't matter. Human principle. Similarity is the urge to find a point of similarity that is deeply rooted in most of us. Psychology studies confirm that even such a small element as your name starting with the same letter as your negotiation partners already builds a common point of reference, brings the parties together, and thus allows them to pass to the task more swiftly and more easily. And third, reinforcement is linked to the procedure itself, to creating at the beginning, when you start a relationship with another party, when you engage in the resolution or the management of a conflict of interest, to build a certain track, a certain path of cooperating together. And here we recommend that before a conflict escalates, you immediately state what you accept as behavior, what you do not accept. Be unambiguous about that, so be clear and precise in your communication, especially when there are linguistic differences or intercultural differences that are involved, and be consistent in your application of the reinforcement principle. That's all in terms of my recommendations and some of the challenges that we face as senior advisors to the UN in my negotiation practice, as well as trainer, and based on what I also have had the privilege of working with my students and them sharing certain experiences, challenges with me. That's what I wanted to convey in a nutshell to you today. We can open the floor for 5-10 minutes.
Great. So that is wonderful. We'll definitely open. I have a few questions to start with, and everybody, please, you are requested that I see there are about 60 people, 62 at the moment over here. And many people are watching on YouTube live as well. So, but first I wanted to ask you myself that what is your personal story? How did you get involved in negotiation in such a deep way? And I'm sure while we can benefit a lot from your, it was a very eye-opening session that you have delivered with so many insights into how negotiations work and very deep insights. But I think we would equally benefit from your personal story and journey as to how did you come to work in negotiation.
I would say by trial and error, and I would say that it all started because I really liked studying, and after I defended my double master's degree, I decided I like studying so much that I decided to pursue a degree, a PhD degree in comparative international law. And then while I was doing my PhD, I still wasn't quite sure, well, in which direction do I want to go? So I was doing a lot of different degrees. I was doing managerial, accounting degrees, finance, and so on. And all the time, I still was not clear as to what my long-term, this question that interviewers always ask, where do you see yourself in 5 years? I had no idea where I see myself in 5 years, but I knew I like to study, and I knew you can never go wrong with developing yourself, which I think is the best recommendation that we can give to people developing in their career tracks. Then I started working for a pharmaceutical company in Paris. And because of my legal background, they engaged me for the first time, I think, in legal contracts and legal negotiations. So I was responsible for contract negotiations, for drafting the contracts, reviewing the contracts, and so on. And that is when, for the first time, I had this clarity of vision that this is actually something that interests me. So it started with practice. And then I was offered a job. I was living in Paris, in France, but I was simultaneously already lecturing. And I decided, well, I'll specialize in negotiations because I'm doing this practically. So I'm going to try to learn more about that. And that's how it started several years ago. More than several years ago. I will not say more than that, because a lady doesn't talk too much about age. So let's just leave it at that. And I got really fascinated, and then it opened. I made contacts, and I moved to Switzerland 9 years ago, and I started making contacts. Then some contacts at the United Nations level with the Schreiner Negotiation Institute, and all of a sudden, all those pieces of the puzzle came together. And this is actually what I'm doing now. So this is what I'm specializing in. Quite recently, I've written a book on this topic, reflecting my approach to negotiations, the negotiation booster, where I combine the strategic procedural elements related to negotiations with self-empowerment in the process, because I believe that tools and tactics that we teach are not enough if you don't have the self-empowerment and conviction that you can actually achieve success in negotiations, all based on, first of all, practice, and then years of research to enrich these practical findings.
Right. If you can throw some light on what was the most difficult negotiation you have ever done, and how did you manage that?
I would say that the most difficult negotiations are usually, I would say, with either your family members, your close family members, or people that you have an emotional attachment to. There's seldom, I often am asked this question, what was the most difficult professionally? Either I've been lucky, or I've been very, very good in implementing the tools and tactics. In my professional endeavors, by far I find the most difficult, and I can't really think of one situation that has been the most difficult. I would say those where I'm personally involved. Okay. So I never will represent a friend or a colleague when my emotional investment is high, because those are those negotiations that are by far those where you violate certain rules that you teach or that you're supposed to apply as a professional negotiator. So those definitely are the most difficult, where you have a personal stake and personal involvement in the process. And hence, one word of recommendation, because this is ultimately what the aim of the question is. So how to resolve those toughest negotiations. What we do as negotiators, and I try to point that also in my personal endeavors, is to distance yourself. In negotiations, we say go to the emotional balcony. See yourself as a spectator, not the person who is involved in the negotiation. Doesn't always work. Sometimes it does, but it's the recommended approach.
Understood. if you can tell us something about one negotiation where you taught us so many principles, but if you can give an example where you had to apply many of these in a professional context, and a little bit of a glimpse into the world of real negotiation.
Okay, so I can tell you about a situation. I'm not going to display the details, but we're dealing with many representatives. First of all, as senior advisors, there's two of us. There's me, and there's also another professor who is of a different origin. So this is what I would basically like to talk about. When we deal with countries where there are clear violations of, let's say, very often we deal with codes of ethics or violation of either child labor cases or breastfeeding practices with big companies involved. I don't want to get into the details and so on. And when we are in a situation between the donor network, so the multinationals very often are those that give the donation, but they are very often also those that will violate certain codes and certain practices according to the standards of and the principles that I've presented to you. And our situation is in that case walking a thin line, I would say, in how to keep the donor, keep the support, because as I told you, one of the elements of our job, one of the principles is to be cost effective and so on. And also on the other hand, how to identify beyond any doubt that there is indeed a conflict of interest, which very often this is the most important part of our job, to identify whether a violation actually exists. Because mind you, the United Nations is not court, and senior advisors, our role is not to say you're right and you're wrong and so on. It's to more to resolve. We're working on prevention and management that certain situations don't happen. So this is one of the interesting cases actually that has been ongoing for the past 2 years actually. Which shows you the level of difficulty because of the multi-party, a lot of actors, our role in the process. Very often certain countries don't have the same legislative systems or regulations as we have. So we also need to understand differences in legal systems and bring all those elements together.
Understood. Professor Jagodzinska, if you can tell us about if somebody wants to become a negotiator, what kind of education can they go for? Like, is there something like if lawyers want to become negotiators, international negotiators, what kind of path they should be following?
Definitely, there are several paths. So first of all, they can enter into cooperation with the one that we're going to start together, Law Sikho and the Webster University. We will introduce together jointly such programs for lawyers, negotiators. Mind you, as a lawyer, I've not had at university, and I hope that this has now changed, I've not had one class on really difficult negotiations. As being trained a lawyer, I have a master's degree in law and a PhD in law, and I've never had a proper negotiation case. So now it's hopefully we're going to change this together. So that's one element we can introduce, and we're going to introduce programs for lawyers who want to be better in difficult negotiations, who want to become skilled negotiators. Then there are professional qualified degrees, such as at the Toronto Negotiation Institute as well. Also, if you want an understanding of the self-empowerment concepts, which I said is very important as well. The Negotiation Booster also has programs designed for women, female negotiators. These programs are very often different than for the standard, I would say, programs, universal or unisex programs, because female negotiators also have a different level of complexity. And there are graduate certificates. Webster has also executive education training centered around specifically training business and legal negotiators. So that's the path I would recommend. And a lot of reading. However, directed reading. Someone has to tell you, someone who has read through enough books that can guide you and give you a good bibliographical framework and say, okay, read this on perception management, persuasion management, communication, intercultural elements, negotiation tools, tactics, self-empowerment, and so on. I believe that a person who doesn't have, who is trained as a lawyer will not have the knowledge where to look for in terms of those references.
Right, right. That's very helpful. There are some questions. Let's take a few quick questions. Ashika Harish is asking, can you please tell a few landmark cases in negotiation? Case law, she's asking, but I think she intends to ask like some of the landmark negotiation she can read about perhaps.
Okay, so what I can recommend to her is to go on the Harvard website, Harvard Business Review, the PON website. They have a database, a huge database of negotiation cases for lawyers as well. And you can choose the topic, family disputes, conflict management, mediation, arbitration, and so on. There are, you can buy it either soft or hard copy, and you can buy a teacher's package as well, which explains the briefs, and you can choose the level of difficulty as well. So there are simple one-on-one cases, such as, for example, the Bentley negotiation, Bentley 1927, one-on-one negotiation, sales buyer, very simple, to more complicated, such as joint venture negotiations, the medley, for example, or salary negotiations with which will require you to identify the underlying interests, such as the Sally Swan song or Sally Soprano. It depends how they title it. But the PON Harvard database is a goldmine of such cases. And of course, if you sign up for trainings at institutes, then we have our own cases that are designed for specifically to address certain prevailing and often occurring main challenges that lawyers have and business people have.
Okay, great. There's a question from Sanjay. He's asking, could you tell us about studying postgraduate studies in law abroad? And does this help if our goal is to become a judge in India? I'm not sure if you will have an answer to this, but this is a question. Maybe you can answer it from negotiation point of view. That
so if I understood the question correctly, it relates to coming
international education,
international, and becoming a judge on the international litigation level. Yes.
Yes. Yes.
Okay. So my advice, first of all, would be to do an exchange in outside of India, because I assume we're talking about someone coming from India who would like to go international. Definitely my recommendation, I don't know what is the procedure exactly. I don't specialize in that. So it's probably a more specific institution could answer the procedural steps related and requirements related to that. From my own perspective, my business perspective, professional, is that you have to do an exchange to understand what are the complexities and what are the differences of the legal systems also outside of your home country. And that's my recommendation to wherever you come from, basically. I have lived in the US, I have worked in the US, I have worked in Paris, I have worked in the Middle East, and only that allowed me to understand the global environment on all these things that basically I've been conveying to you today in theory. They're supported by my practical experiences. So I draw from the situations that I had and encountered in doing business. There's no other way.
Okay. There's another question. There's a question is that my husband is doing his LLM from United Nations Turin. United Nations in Turin? I guess it is a university name in Turin. And right now he's in Geneva and really eager to work at the United Nations. What could he do? Maybe you can have any advice.
I recommend he goes on the UNOPS website and checks out what are the current internship possibilities or job openings that would be tailored to his specific line of expertise and professional interests. UNOPS.
Okay. There is a question from Gisby and Bose. I'm an advocate with LLM degree in public international law from London and interested in working for the United Nations. Can you guide me as to how to go about it? Okay, very similar question. I'm inclined towards negotiation as a method of dispute resolution.
Isn't that a little bit similar to the question that we had
Exactly,
earlier?
very similar question. Yeah.
So my answer would be the same.
Okay, so United Nations OPS website.
UNOPS, yes, exactly. And there you'll have a whole directory, I would say, of openings and the levels, and also the requirements and different units and so on, and different locations.
And do you have to build up a profile so that you get qualified, or certain kind of work profile?
That depends on the level, and that depends on the specific. Some openings are very specific and some are more general, in the sense that it depends on the level as well. It depends on the unit. Some are more general in what they need as the candidate profile, and some really narrowly seek for a specific skill set. So that obviously I don't know all of them.
Okay, so basically studying them will give one ideas about what one.
Exactly, yes. And what is the type of words that you should use, and what is the skill set that they're looking for, and so on.
Great. That's very helpful. Does Webster University offer any degree, master/doctoral related to arbitration and negotiation? Question from Neeti.
Yes, as I mentioned, I'm the director of executive education at Webster, and we have programs specifically designed on enhancing your negotiation, executive education trainings and certificates that evolve around that.
I think she wants to know if you have a master's degree or a doctoral program specialized.
We have the doctoral and master's program in international relations, which would be a very nice fit for a lawyer or a person or a candidate with a legal background.
Wonderful. There's a question from Valerie. She's asking, what career options can one have after having an LLM in international and comparative law? I think this is a question we very often get. People want to study international law, and they find not that many career opportunities after doing international law, especially Indian students, Indian law graduates. So if you have any suggestions, what are the different career options in international?
The different career options is you can either be in-house counsel for multinational companies. You can be also an advisor to the United Nations. Obviously, a possibility is always to set up your own legal practice internationally, or to set up a company with other sister companies internationally, grouping specializations, a law firm, be it national or international. So I would say a career also in executive trainings, consultancy, and so on.
Okay, so we have many questions. Otherwise, some of them are repetitions.
I have 5 more minutes. So
yeah, we are 5 minutes past 7 already.
Yes,
so,
exactly. So I have 5 more minutes before my next engagement. So please be selective. Yes.
Sure. So one question that I have, many people are asking, is that if we want to get in touch with Professor Jagodzinska, how can we do that? Like, can you share your LinkedIn profile, or maybe you can share your email, whatever is okay with you?
I invite you to also visit my website. It depends in relation to what, because if it's in relation to programs, I would recommend that we're going to be introducing jointly between Webster and Law Sikho. I would recommend that it goes through you.
No, they'll go through us. We haven't announced it yet. Their questions are related to, like, they might have some follow-up questions or inquiries about Webster or anything.
And then LinkedIn, please.
LinkedIn, right? So I will share with everybody Professor Jagodzinska's LinkedIn profile in a moment with all of you. So, and you can even, for that matter, find it yourself, but I will still make it easy and share it here with all of you. Okay, in a moment. Yeah, I have it. I'll share it on YouTube also, just in case anybody, all the people who are watching on YouTube, if you are interested, you can access it also. Okay, so you can get in touch with Professor on her LinkedIn. And okay, so couple more questions. We'll just take one more question, I guess. Somebody is asking, Arpit is asking, I'm currently interning with a negotiation consultancy firm in Berlin, while also pursuing my LLM in international dispute resolution here. What would you advise me at this stage to pursue a career in international negotiations? Would you have any special recommendations for somebody working in?
I really find these types of questions too personal in the sense that I do not see myself in a position to advise someone what is the career track that they should pursue.
Right.
I think that that depends on the individual skill set. I never allow myself to provide such recommendations. I can say what are the possibilities, but I do not know the skill set of the person. I do not know the interests. All I can say is what the path that I've been through, and that when you are interested in, let's say, a specific branch of law, you will know which one interests you and try to pursue and develop in that direction. And then you can never go wrong with developing and growing and getting more insights, more multidimensional. Basically, I would say the broader the education, the better. So unless you really want to be specific in a branch, which I find limiting. So if for example, I specialized only narrowly when I used to live in Poland, that would be a disadvantage for me now at the international level. So I would say develop as many skills law related that you can, or negotiation related, and try to expand your horizon in relation to understanding the differences of the legal systems.
Great answer.
But otherwise, I really cannot offer personal advice like that, because
Right.
it's simply too private a matter, I would say.
Great. So in that note, we are going to end the session here, but there's a question from Mohit Tang, which I find very interesting. And I'm going to ask this. It's a short question. Like, if you are working in international negotiation, is there a lot of traveling involved to exotic locations? And how is the work-life balance? Yeah.
I don't know what he means by exotic locations, because I assumed Geneva, Switzerland would be an exotic location. Yes, there's quite a lot of travel involved. Like I said, I conduct trainings in the US, the Middle East, all over Europe. So yes, if there's no pandemic, then travel is one of the highlights, I would say. Yes, right. And meeting a lot of interesting people while traveling.
Great, wonderful. Thank you so much for your time. It was a lot of in-depth discussion and many questions. And thank you so much. And really appreciate you sharing your time and your insights with us. Looking forward to work more with you. Thank you very much.
Thank you. Please share the YouTube link with me.
Yes, absolutely. I'll share it right away.
Okay.
Thank you very much.
Thank you. All the best to everyone. Have a nice evening and nice afternoon to the people that are in Geneva. All my best to all of you.
All the best.
Bye-bye. Thank you. Bye, Ram. Bye.